in order to give use immunity, because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding. And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5-507. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
You guys could have been anywhere in the world, but you're here with me, and I appreciate you guys for trusting the process. Make sure you like, comment, and also subscribe to the channel. Now let's get to the content. So today we got no other than YSL Woody. Now YSL Woody, he was a former member of YSL. Now it looks like YSL Woody will have his chance to throw Young Thug under the bus. Now if you guys remember, it was video evidence that came out maybe a year ago, and it showed YSL Woody in the interrogation room. He was so distraught in that room after the things that he said that he had even checked his blood pressure to make sure he was still alive. Now, seems like he tried to recant some of his statements, but we know how the judicial system works. They're not going to let him forget or forgive anything that he told them. Now, he got immunity in this case, but he said he's trying to plead the fifth. But like the judge tells him, immunity overrides everything about pleading the fifth. So we're going to get into this, and then I'm going to be back with some more commentary, because we got some things we need to talk about the situation.
He is present in the courtroom, Judge. Okay. What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Come on up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please, Guy?
Yes,
I need 2 copies of it. Actually, 3.
You're signed.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We had a proposed order.
But I signed the order this morning, though.
I meant the manner in which it was filed will not be made public.
Okay. All right. Which copy's been given to Mr. Copeland? The order pursuant. All right. All right. Do we have extra copies of that? Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are, and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony. And our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So, you've been subpoenaed in this case to appear before and give testimony in this particular matter, and state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay, you've taken a fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's given you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So if they ask me a question that implicate me, then...
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways, like you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him. So I testify.
You will testify.
Yeah.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. We'll formally administer the oath to you, and then the state will ask you some questions, okay?
So as you can see, YSL Woody, he was trying to weasel his way out of testifying. And he thought he had all the sense by saying he's going to plead the fifth. But like the judge told him, you have immunity. So all they want you to do is testify. And he made a smart remark like, well, I could just tell him anything if I had to testify. Yes, you could, but they're going to have all your recorded statements. They're also going to have the recorded videos of you saying exactly what you said at that time. Now they're going to ask, well, why are you saying something different? Now, the judge also said if you refuse to testify, he will lock you up. And you guys know that YSL Woody, his rap sheet is longer than Georgia itself in the square mile radius. So he's going to be looking at a hefty sentence. And he don't want to do that, because if he did, he would have stayed silent and didn't tell on Young Thug and YSL at the beginning. But I need you to get you guys' thoughts on this, because right now, once they get him in that chair and he begins to talk, it's definitely not going to look good for Young Thug. But this is Checking and Jive TV, and until next time, let me get the hell up out of here with my little channel.